Welcome back to the Emily Show. This week we have so much to talk about. Why? Well, the judges are mad. And today we get to talk about everyone's favorite topic. I think this is the thing I get asked about as much as why isn't that a hostile witness? Y'all know the answer if you've been watching trial with me. You know the answer now of what a hostile witness is. This is the thing I get asked about as much. Perjury. And today we actually get to talk about it. Emily, you sound way too excited to talk about perjury. Oh, I am. We're also going to do some quick Diddy updates on what happened with the Menendez brothers resentencing this week. The federal judge in the Lively Baldoni case is big mad. And Judge Hippler in Idaho, I think, is actually more pissed than the federal court in New York. So with all of that, not only do we have a lot to talk about, but we have some court that we are going to be bringing in today because there are some moments that we just need to chat about that I haven't had a chance to cover yet, because the day-to-day trial streaming of the Karen Read case has taken A, quite a bit of time, and B, it has been more surprising than I expected. It is a retrial. There should not be surprises. And yet, day over day, I'm like, what? So if you want to make sure that you are tuning in with me daily, or you just see the witnesses that you want to see most, make sure you get the Law and Order app. We let you know who's on the stand. So if you're like, please, I don't want to be here for an entire day of marking 7-11 and what's in that photo. That's fine. We'll let you know in the Law and Order app when we move on to some of the critical prosecution witnesses as we come to the end of the prosecution's case. And then when we get into the defense's case in chief, there are still some big lingering questions about who the prosecution is going to call. And those should be mostly cleared up next week. And it's a shorter court week with a half day Thursday and a day off Friday, getting ahead of that Memorial Day weekend, which we will be observing too. Why? Because I have to take my kid to move in for the summer. So I'll be traveling. So we will be getting ahead of everything that's coming up in the next 2 weeks right now. I'm legal analyst Emily D. Baker. Yes, also a lawyer. And this is The Emily Show. I break down the pop culture, entertainment, and high profile cases that we're all talking about. I know you want the facts, so let's get into it. We talked briefly in a previous episode about the Menendez brothers and their bid for resentencing, which was filed by the previous LA County District Attorney. The newly elected LA County District Attorney sought to revoke or withdraw that motion. The court did not allow it, and that hearing finally, after numerous hiccups, went forward, and the judge determined that both Menendez brothers should be resentenced to 50 years to life instead of life without the possibility of parole. What does that mean? Well, it means there is the possibility of parole, and that could be imminent. But the parole board still has to decide if parole will be granted now. But it gives them the opportunity to revisit with the parole board, even if parole is not granted now, in the future. So there is a possibility that they could be paroled down the road. This is separate from their clemency proceedings that are still ongoing. So there are still 2 legal avenues moving forward. The next hearing in that case is going to be on June 13th for a hearing at the parole board. And yes, the district attorney's office can make objections at the parole board if they feel that parole is inappropriate, and the parole board can either agree with that or not agree with that. You can also have members from the Menendez family and from the Menendez victims family going to the parole board and asking for parole. So in June, we will likely know more about whether or not the Menendez brothers will be released, but this is not an imminent release. There are still decisions to be made from the parole board. But in the future, even if it's denied in June of this year, could that happen down the road? Yes, it could. Let's talk about the first week of the Diddy trial, because if Diddy is convicted of what he is charged with, the baseline sentencing option is life, period. And this was a very busy first week of trial because the prosecution has put in some of their key witnesses in the first week. We know that this is going to be an 8-week trial. I am still surprised that this started on time, and it did. The defense has a tremendous amount of lawyers, which helps this case start on time because of the depth and breadth of the legal team just based on Diddy's own wealth. He can hire a fleet of attorneys. Most people can't rival the federal government with the amount of hands on a case they can have. Diddy is one of those defendants. There were numerous witnesses this first week, but the, I think, most anticipated witness of this trial was Cassie Ventura. I talked about the civil lawsuit with Cassie and Diddy, so that will be linked below if you want to go watch that breakdown. When I break down the Diddy case, I do not get into every single detail that is explored in court. It is a tremendously difficult case. There are facts that are just absolutely egregious and horrific. I don't have many other words for the things going on in the Diddy case. I am not going to get into all of the graphic details of what's going on in trial. My goal is to give an overview of what's happening week by week because there is so much coverage of every single detail in this case. And at some points, it is going to be too much for most observers of this trial because it is not going to get better. There is an ongoing fight over the sealed videos of the so-called freak-offs. I think the court will leave those sealed. I think the court should. I am not going to fight for the media to have access to those, as Diddy was using those as blackmail of the victims. And when victims chose to come forward and civilly sue and go to trial, I don't think then those blackmail materials should be released out for the media for all time. And that's just where I stand on it, because though they have testified in court, though they have detailed the horrific things that have happened, the videos do not need to be public. But the extensive video of the Intercontinental Hotel has been released. That is on the internet, and it is the full video with multiple camera angles that had not previously been released by CNN. So there will be some things that are evidence in court that will be in the public domain. Will I be showing them here? No, I won't. Can you find them easily? Yes, you can. This is not easy testimony to give. And the defense has maintained the same defense strategy that we've talked about since the beginning of this case. When I attended the initial detention hearing, the defense was arguing that this is a consensual relationship, that Cassie Ventura wanted to be in this relationship, and that she had millions of reasons, alluding to a settlement made between her and Diddy, to go to criminal court. Well, she already has the settlement. I don't think it's going to fly arguing to the jury that she just wants the settlement, so she's coming to criminal court to be cross-examined for days. But we'll see. And in opening statements, the defense followed that argument that these were consensual relationships, that yes, Diddy was abusive, and yes, he was violent, but that is a domestic violence case, not a sex trafficking case, not a RICO case. It is a smaller case, if you will, between two individuals. That's not how the government charged it. And I don't know if by the time we get to the end of this case, 8 weeks from now, jurors are going to agree that this is not people being transported across different states for the purposes of prostitution and of sex trafficking. I don't think the jury is going to agree with the defense. And unlike a lot of cases, so much is on video. So the defense is going to try to say, look, there are things in this relationship that weren't great, but those things don't equal what the government is charging here. So try to admit some of the wrongs that are inevitable because they're on video, and then try to say, but those don't match these charges. With all the videos that are going to come in this trial, I just don't think it's going to be persuasive. And it's not just videos. You have numerous eyewitnesses that support what the victims say in court. And yes, in court, they will be called alleged victims. I'm sure that is going to feel wrong to many watching the court proceedings. However, in a lot of jurisdictions, the victims are not allowed to be called victims until there is a conviction, because it can be unduly prejudicial to the defendant. So it really does depend on the jurisdiction how victims will be referred to in court, whether they will be referred to as alleged victims or accusers or just by their names. But that is a legally appropriate thing. But if it rubs you the wrong way, there is also a chance that it rubs the jury the wrong way, because they are going to see so much of this case with their own eyes, which you don't normally see in trafficking cases. It's not normally all videotaped. At the end of the week, Cassie had finished her testimony. We are going to see others that are named victims in the case come in, others who are not named victims in the case come in. Why? Because with the racketeering charge, the government can bring in bad acts, essentially, that go back well beyond a normal statute of limitations, because they can kind of link them together like a chain and show a pattern of behavior, including a pattern of covering up behavior. And we already saw some of those witnesses talking about that hotel video. When we go through witness by witness, there will be witnesses who have had things happen to them that are not named victims in the case because of that RICO charge. We will also hear about things like civil settlements, which we heard with Cassie Ventura, that her settlement with Sean Combs was $20 million. That was not publicly known before this trial. We knew that there was a settlement. She filed her civil lawsuit, and the next day it was settled and withdrawn. But it was out there. And that lawsuit lined out in detail the things she talked about in her testimony, which she talked about in more detail. The thing that I was surprised about is that she's actually undergoing a settlement with the hotel that buried the video. I don't know if that's going to dissuade jurors after they saw the video. In some cases, jurors do not like to see victims or alleged victims on the stand that have already had civil settlements. But I think in this case, when they see the videos, they're going to understand. And I imagine that many will. But I also appreciate that even though that settlement's not done, that she testified about that settlement and said, yes, it looks like it will be a $10 million settlement with the hotel as well. Do I think that Cassie Ventura is testifying in this criminal case for money? No. Will the defense argue that? Yes. But the civil cases have already settled. So why get on the stand for 4 days and testify and go through cross-examination if that was the goal? Because that goal had already been achieved. I don't find it a persuasive argument, but we also know from court filings that the government has lost contact with another one of the named victims that they added in those subsequent indictments. And it will be interesting to see if they are able to reestablish contact with that victim or if that will not be brought in court and we will see either charges that go specifically to that victim dropped or just not found. Generally, what happens if you get to the end of the prosecutor's case in chief and there are things they have not proven, then those will just be stricken from the indictment. Does that change the time that Diddy's facing? No, it doesn't. Even if there are a few things stricken, because the main indictments that he is facing carry so much time, it's not going to change it that much. So there will be 8 weeks to 10 weeks of the Diddy trial. Again, it will be attended in person only in New York Federal Court, no audio, no video. If anyone wants to attend court, well, it seems that the lines are very long, but there are overflow rooms. And bring notepads. You're not allowed to have anything digital unless you're already a member of the media. And there are numerous accounts that are retelling that on X and Blue Sky and Patreon and elsewhere. So you can follow almost real-time coverage of the case via text. But we've got another 3 weeks of the Karen Read trial. And that's what I'm going to be covering day to day. Well, Honored, it's not a surprise that I am often running late and at the speed of ADHD, so anything that can simplify my routine is a win-win for me. And Oneskin absolutely does that with the skincare routine in one step handled. I love that I don't have to think about all the different things I might want to put on my skin so that it is looking its best as I am aging, because I'm here to age. I would just like to do it gracefully. And Oneskin was founded by an all-woman team of scientists with PhDs in skin regeneration and stem cell biology. Their proprietary OS1 works at the cellular level to improve key aging biomarkers while reducing the visible signs of aging, including lines, wrinkles, and sagging skin. So it's not just skincare, but it's here to make your skin more resilient to the aging process without completely overtaking your bathroom. Oneskin is the world's first skin longevity company, and by focusing on the cellular aspects of aging, Oneskin keeps your skin looking and acting younger for longer. And isn't that just what we all want? For a limited time, you can try Oneskin with 15% off using code LAWNERD at oneskin.co. That's 15% off at oneskin.co with the code LAWNERD. And after your purchase, they're going to ask where you heard about them, so be sure to let them know that the Emily Show sent you. So please support the show and give your skin the scientifically proven and gentle care it deserves with Oneskin. Let's get back to today's show. The judges are mad. The first judge we're going to talk about is the federal judge in the Lively Baldoni case and what the judge is mad about. But I have to give a caveat on that with like a big asterisk that there are hundreds of pages of filings that we have just not had time to go through. So we are skipping a little bit ahead in the process. There is still a lot of ongoing litigation with regard to motions to dismiss and the rest of it. Have we gotten to dive into all of that yet? No, it is so much to be covered. And I don't cover it from other summaries. I want to read through all the motions myself, but they are verbose. And that is what brings us to the judge's order today. It is the lawyers and what they are using the docket for. This is going to tie into a theme that we are starting to see in court more and more, is that lawyers are very aware of the litigation immunity that attaches to filing things in court. I speculated when we got into this case and when I saw how lengthy and on information and belief the initial filings were in these lawsuits. And I said at some point, federal judges are going to want to rein in the amount of things that can be alleged. Complaints are supposed to be an overview of what the complaint is and what the facts they expect to establish will be. It's a summary. It is not every single thing in the world. And it is also supposed to be based on factual evidence and some on information and belief that you think you will prove later, not all on information and belief. And I wondered if we will start seeing judges get more frustrated with their dockets being used as a way to put things out publicly without worry about repercussions. And that's really what the judge in the Lively Baldoni case is saying in this order. There were allegations levied by Baldoni's attorneys that Lively and Lively's attorneys had blackmailed Taylor Swift. And this is all over a subpoena that is happening in Washington, D.C. to try to subpoena things from Baldoni and the Wayfarer side vis-a-vis Taylor Swift. So you've probably seen these headlines with regard to whether or not Blake Lively was blackmailing Taylor Swift and some fairly salacious allegations. But the court has stricken all of those filings off the docket. The court immediately yeeted both filings that refer to this in any way because the judge is over it. So let's take a look at this judge's ruling because the order is pretty strongly worded on how frustrated the judge is with these types of filings. So this is the judge's order from May 15th, 2025 in the Lively Wayfarer and Wayfarer Lively Reynolds suits. They are combined in a heading because the suits are consolidated on one docket. Blake Lively moves to strike a letter, docket number 217, the letter filed in this case on May 14th by attorney Brian Friedman on behalf of the Wayfarer parties, footnote 1, which says, the Wayfarer parties are Wayfarer Studios, LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz, It Ends With Us Movie, LLC, Melissa Nathan, The Agency Group PR, LLC, and Jennifer Abel. For those of you that it's been a minute, yes, that's my footnote voice, which is docket number 218. This motion is made pursuant to the court's inherent power to prevent abusive or improper use of its docket. The motion is granted. The court's like, do not abuse my docket. I'm not happy. Courts have the inherent power to, quote, manage their own affairs so as to achieve the orderly and expeditious disposition of cases. This includes the power to strike materials outside the pleadings that are, quote, abusive or otherwise improper. And the court is quoting a substantial amount of case law that substantiates that point. Going to footnote 2, Rule 12F of the Federal Rules of Civil Procedure allows the court to strike a matter within the pleadings that is, quote, redundant, immaterial, impertinent, or scandalous. No scandal. That is not what the courts are for. The court goes on to say the Second Circuit has emphasized, they have put emphasis on it, that courts should protect the judicial proceedings from being co-opted to promote scandal arising out of unproven, potentially libelous statements. It is stated that a district court not only has the power, but also the responsibility to exercise, quote, supervisory power over its own records and files to ensure that they are, quote, not used to gratify private spite or promote public scandal or serve as reservoirs of libelous statements for press consumption. That is a quote from 1978. So 1978, the courts were worried about dockets being used to gratify private spite or promote public scandal or serve as reservoirs of libelous statements for press consumption. And in 2025, have dockets also served that purpose in some very high-profile cases? Yes, we have seen in this case, both sides make accusations about the other that don't move forward the litigation in the underlying suit. There's a lot of back and forth finger pointing and a lot of information that's just not relevant to the suit, but it's not just this one. There have been plenty of suits that we've seen. It's like, well, none of that's relevant. And this federal judge has made a warning to everyone that it is not going to be happening on this docket. The court says of the letter filed by Baldoni's attorney, Brian Friedman, that the letter is improper and must be stricken. It is irrelevant to any issue before this court and does not request any action from this court. If you are not requesting the court to take action, why are you filing anything? We also saw this play out when the federal court got really annoyed in the Jay-Z Diddy related civil suit when the court basically said to Attorney Spiro, stop filing things. There is an order and a process here. There are rules, people. It goes on to say that the letter concerns a subpoena proceeding in the District of Columbia over which this court has no authority. The federal court in New York can't call up the court in DC and say, yo, do this. It's not relevant to these court proceedings, even if the subpoena may be used in these court proceedings. The subpoena itself, this court said, is not within our jurisdiction. It is a foreign subpoena in DC. The court goes on to say, and you now know when the judge is mad, the sole purpose of the letter is to, quote, promote public scandal by advancing inflammatory accusations on information and belief against Lively and her counsel. It transparently invites a press uproar by suggesting that Lively and her counsel attempted to, quote unquote, extort a well-known celebrity. Retaining the letter on the docket would be of no use to the court and would allow the court's docket to serve as a reservoir of libelous statements for press consumption. The same is true for the Wayfarer party's subsequent docket submission at docket number 219, which the court will strike sua sponte, which means of the court's on motion. The court's like, you didn't even ask for this, yeet. For the same reasons. The Second Circuit has noted that court filings may be abused to make potentially defamatory statements without the threat of liability, given that under New York law, quote, absolute immunity from liability for defamation exists for oral or written statements made in connection with a proceeding before the court. It has advised the press accordingly that although the act of filing a document with a court might be thought to lend that document additional credibility, in fact, allegations appearing in such documents might be less credible than those published elsewhere. And the court is saying that, citing case law, saying that, look, you can't be sued over things that you put in a court proceeding. The lawyers can be held to account in other ways like this. The court said the motion to strike is granted. The clerk of court is directed to strike docket number 217 and docket number 219, and then gave the correlating case numbers because these are consolidated. The court closes with, counsel is advised that future misuse of the court's docket may be met with sanctions. So ordered. I read that as a warning to all counsel, not just to one side's counsel, but to all counsel. Stop it. Do not use the court's docket to promote public scandal by advancing inflammatory accusations. The court has laid the hammer down in this case, and I think after this, we might see the docketing be maybe less salacious, but it's why some of the filings are so incredibly long, and we have seen it from both parties. And I was critical of it at the beginning of the case. There are some filings that just had so much information in them that weren't really relevant to the underlying accusations or to moving the causes of action forward. And then both parties were like, oh, this is what we're doing. And everybody just jumped both feet in. And then the docket length just exploded because everyone was like, oh, okay, I guess we're doing this. And all of the lawyers have stepped up the accusation against one another, the accusations of what the other side is doing, and it keeps turning up the heat. And this happens more often in civil cases than it does in criminal cases. The rules are a bit different in criminal cases because of what you're dealing with, but that doesn't mean you can't have scandal within a criminal case. And the next two cases we're going to be talking about are exactly that, scandal within criminal cases, both in South Carolina and in Idaho. First, we're going to talk about Courthouse Becky. Why? Because I have been wanting to talk about this all week. We have been very busy in court and we haven't had a chance. If the name Courthouse Becky does not ring a bell to you, don't worry. I will give you the real quick version and then I will link down below all of the videos covering the lead up to this because this has been brewing for quite a while. So dear old Becky Boo, the clerk of court for the Murdaugh trial in South Carolina. At the end of the Murdaugh trial, the defense started making allegations that the clerk had interfered with the jurors, had spoken to the jurors, had insinuated or directly stated, depending on who you believe, that nothing the defense says can be believed, and had influenced the jury. This went to a hearing before not the trial judge, but a stand-in judge on a motion for new trial. That litigation is still ongoing on appeal. We will get back to it because there is actually some really interesting legal things that are happening there. And if South Carolina decides to change their standard to match what the Supreme Court of the US has done, it could result in Alec Murdaugh getting a new trial for these murders based on this clerk's action. That could result. For now, the way the law is in South Carolina, that's not what's going to happen. But there is a possibility that the court adopts the newer standard for this case. I've talked about that at length, so we won't get into it today. But there is a possibility that these issues cause a retrial in the murder case that Murdaugh was convicted of. Murdaugh was convicted of the murder of his son and wife. The jury was out for a very short amount of time. So after that trial and sentencing, we saw this hearing in front of Justice Toll, who is a former Chief Justice of the South Carolina Supreme Court, where Becky Hill was on the stand under oath and questioned by the prosecution and the defense. Part of what Becky Hill was questioned about was her interactions with jurors, and part of what Becky Hill was questioned about is this book that I got before it was yeeted off of everywhere. Why was it yeeted? Plagiarism is why it was yeeted. There are things directly plagiarized in this book, and it was yeeted. But this book is part of the issue, amongst other things. When I said we were going to talk about perjury, we are, because it's one of the charges that Becky Hill is now facing. I covered her ethics complaint in depth. So if you want all of the tea on the ethics complaint, that video will be linked down below, and you can watch the whole breakdown of the 70 plus ethics allegations. But today, we need to talk about the criminal case. There are now 4 counts pending against Becky Hill, and yes, she has been released on bail, so she is not yet Jailhouse Becky. She is still Courthouse Becky, and she is going to be frequenting the courthouse because these cases are going forward in 2 different counties, 1 in Richland County and 3 in Colton County. The criminal charges are stemming out of her behavior as the clerk of court in the Murdaugh case, among other things. And the perjury charge, yes, perjury, stems directly out of that hearing that I covered with Justice Toll. So we're going to take a look at the warrants for arrest and the summary of the charges. We're going to talk about perjury, and I think we should just watch the questioning of Justice Toll, don't you? I know that you do. I do too. Emily, you're smiling too big. Yeah, it's really rare when you have an ethics complaint that prosecutors will take it the next step forward on a perjury case. It is incredibly rare that they will go forward. There are many times you see things and you're like, that's not accurate. And it is not pursued because perjury cases are difficult. How can you prove that someone is lying, especially if an answer or a series of answers is evasive? But it's not just perjury that she's charged with. Emily, you're too happy. Look, man, do not fuck with the jury. You're the court clerk. You're making like $100,000 a year. You have an elected position. Why are you trying to put your hand on the scale of justice? Literally, what the fuck? Also, Becky Hill is innocent until proven guilty, but I have strong feelings about this case because we watched it unfold. So first, we're going to take a look at what perjury is in South Carolina. Then we're going to take a look at the warrants against Becky Hill. In previous content, I went over the public records request of Becky Hill's emails. And in emails back and forth to the media during the Murdaugh case, she would sign some of them XOXO Becky Boo, like with her bestie, Nancy Grace, who she was like, oh, here's my cell. Let me know if you need anything. The way that she was treating an influence during the trial, looking at her emails, was infuriating to me. It was, Oh, don't worry. You don't have to wait in line. I can let you in the side door of the courthouse. Oh, don't worry. You don't need to do anything. It's fine. We've got you taken care of. She was using her position, her elected position, to trade favor and power with members of the media and others to do favors so they could have prime seating in the courthouse of the trial of someone she went to high school with. And in her hearing with Justice Toll, she's talking about how her granddaddy and granddaddy Murdaugh all knew each other and they all live in, okay. And then at some point had her daughter out performing like guitar and singing for the media, who were then financially supporting her kid and like sending her Venmo payments. That's not what you're supposed to do with your elected position. And if it had just been the trading in favor and if it had just been the media stuff, she might not have gotten prosecuted. But it was so much more than that. So perjury. I know we never get to talk about it. Emily, you always talk about the perjury trial you did. Yeah, because there was only the one, because they're hard cases to take to trial. Perjury, offenses against public justice. Doesn't it feel that way? Like, could anything be titled more perfectly than South Carolina? Offenses against public justice. My public justice is offended. It is unlawful for a person to willfully give false, misleading, or incomplete testimony under oath in any court of record, judicial, administrative, or regulatory proceeding in the state. A person who violates the provisions of subsection A1 is guilty of a felony and, upon conviction, must be fined in the discretion of the court or imprisoned not more than 5 years, or both. How do I think judges will look at a court clerk who is accused of the other actions and then lying to a justice about those actions? Not fondly. When you are part of the justice system and abusing your power, it is not going to be taken well. If it causes a potential retrial based on her behavior, nobody's going to be happy. It's a huge waste of public resources. And the allegation is she was doing that to what? Sell more books. The clerk that testified about her conversation with Becky Hill at that hearing, which we will link my coverage of below, that clerk said, well, she thought it would be better for book sales if there was a guilty verdict. Well, the judge is going to look at that and say jail. Jail. We'll take a look at the alleged perjury ourselves after we take a look at the warrants for arrest. This is a press release from the South Carolina State Law Enforcement Division. You might recognize them as SLED. Yes, Nightbot had to explain for like 6 weeks what SLED meant. This is what SLED means. SLED charges former Colton County Clerk of Court with perjury, obstructing justice, and misconduct in office. South Carolina Law Enforcement Division charged Mary Rebecca Becky Hill, 57, with perjury, obstructing justice, and 2 counts of misconduct in office on Wednesday, May 14th. SLED was requested to investigate by South Carolina Attorney General's office. Details can be found in the attached warrants. Hill was booked into the Colton County Detention Center, then the Alvin S. Glenn Detention Center in Richland County. The case will be prosecuted by the 11th Circuit Solicitor's Office. And then they gave the press inquiries email, and now we get to the warrants. These are the filing documents in South Carolina. They list out the charges and which county. Yes, they charge things in the county where it happened, county by county. They sometimes will bring those together for trial, but what I've seen mostly is that those trials go forward in the county where they're supposed to be. This is from Richland County. This is the perjury charge. And it reads as follows: that in Richland County, South Carolina, on or about January 29th, 2024, I forgot that that hearing was on January 29th, that Mary Rebecca H. Hill, being the elected clerk of court of Colton County, did willfully and unlawfully give false, misleading, or incomplete testimony while under oath in a court of record, judicial, administrative, or regulatory proceeding in violation of section 1609-10A1, that's the section that we just read together, of the South Carolina Code of Laws. During the hearing, sometimes the word former just feels so appropriate and aggressive. I'm here for it. Former Clerk Hill did willfully and unlawfully give false and misleading testimony when Chief Justice Jean Toll asked former Clerk Hill, quote, "Did you allow anyone from the press to view the sealed exhibits?" And Hill responded, quote, "No, ma'am." This statement was inconsistent with the events of February 28th, 2023, when former Clerk Hill did release or make available sealed evidence photographs to a third party or parties. And part of the reason this makes me so mad is that the photos that were released to the press were photos of the deceased victims. It's not appropriate, and it's fuckery. And I'm glad they're prosecuting it. There are some cases I come into and I'm like, let this play out. This case we watched unfold, and I'm glad they went after it. Abuse of office should be prosecuted. It's not prosecuted often enough. But allowing the media to have access to photos of deceased victims is deplorable, and you should go to jail. So if you want to know where Emily stands on this one, that's where I'm at. Let's see what the other allegations are, because we watched the perjury happen right before our eyes and we saw the photos released to the public. So did we all know it was a lie when it happened? Yeah, we did. And I think so did Chief Justice Toll, but we'll get there in just a minute. This is essentially count 2 from Colton County. Quote, that in Colton County, South Carolina, on or about February 28th, 2023, that Mary Rebecca H. Hill, being the elected clerk of court of Colton County, did unlawfully commit an act which prevented, obstructed, impeded, hindered, or potentially impeded or hindered the administration of justice. Yes, obstruction of justice. To wit, while preserving evidence during the course of the General Sessions murder trial of Alexander Murdaugh, did release or make available quote-unquote sealed evidence photographs to third party or parties, such act occurring in violation of a written court order issued to protect the sealed evidence photographs, in violation of the law of the state of South Carolina. That's the obstruction of justice charge. The next charge, also from Colton County, is that on or about June 7th, 2023, Becky Hill, being the elected clerk of court, did willfully, dishonestly, and unlawfully breach her duty of accountability to the public as imposed by law by failing to properly and faithfully discharge said duty. To wit, Hill did promote a book in which she was the author, quote, Behind the Doors of Justice, The Murdaugh Murders, while using her public office to promote the aforesaid book on social media, such act being for her own financial gain and in violation of her duties. There's a lot more to that is not charged here, but it's in the ethics complaints. If you're curious, I covered them all. And then this is the next charge. On or about September 1st, 2021 through March 5th, 2024, Mary Rebecca Hill, being the elected clerk of court for Colton County, did willfully, dishonestly, and unlawfully breach her duty of accountability to the public as imposed by law by failing to properly and faithfully discharge her duty. To wit, Hill requested and then received $9,880.10 in financial bonuses for herself that were paid from the Title 4D incentive funds. Such funds were obtained by Hill and utilized for her own financial gain. Furthermore, on or about March 5th, 2024, Hill received a financial gift and or bonus in the amount of $2,000 paid by a check from the Colton County Clerk of Court's office funds and utilized for her own financial gain in violation of her duties and further in violation of the laws of the state of South Carolina. In case you are wondering what the Title 4D funds are, those are funds that are provided to the state through a federal and state partnership to support child support enforcement efforts. The funds are used to help locate absent parents, establish paternity, and enforce child and spousal support obligations. So the money that she is alleged to have taken was from funds that were intended to help enforce child support payments. Those allegations are also included in the ethics complaints that we saw. And when we saw the ethics complaints become public, it was clear that SLED was investigating then. But since we have a perjury charge and it is lying under oath of a streamed proceeding, I think we should just look at how that all went down. So for those of you listening on audio, we're going to be going to court now with Justice Toll questioning former Clerk of Court Becky Hill on the stand at that hearing that she is now being charged with perjury for from January 29th, 2024.
The judge brought up another thing right after sentencing that I want to explore with you briefly.
Okay.
All right. One of the big responsibilities of the clerk of court is to take control of the exhibits that are presented in court. Isn't that correct?
Yes, ma'am.
And there were sealed exhibits presented in this case that were photographs of the two decedents at Moselle when the law enforcement authorities first investigated the murders. You recall that?
Yes, ma'am.
And
Yep.
those photographs were sealed by the judge, were they not?
Correct.
And when the testimony about them was completed, they were under your control as the clerk of court, were they not?
That's correct.
How was it that those photographs came into public view?
Are you talking about after the...
I'm talking about the fact he alluded to it on sentencing and said that he was frustrated about it and was going to try to look into it.
The judge was mad.
Those photographs that were sealed court exhibits under your control found their way into the public media, did they not?
I believe they did. And I think what happened,
they did.
Someone from the gallery took a picture from a screen that had some of the pictures on it, if I'm remembering correctly.
Did you ever allow anyone from the press to view?
That pause was the judge blinking at that answer. Former Chief Justice of the South Carolina Court blinking at that answer, and then her face goes, okay, that's a bold answer. You can see it. And then she asks the next question.
Did you ever allow anyone from the press to view these sealed exhibits?
No, ma'am.
Did you allow Netflix to ever examine the exhibits for trial?
No, ma'am.
And with that question, did you allow anyone from the press to view those sealed exhibits? No, ma'am. Why is this a perjury charge? Because they believe they can prove that that answer, no, ma'am, is not accurate. And I have to wonder, because courthouses have security cameras, if they have this on video. That would be one of my big questions, because courtrooms have security cameras. I also would imagine that the members of the press who got questioned about this explained how they had access to those. And don't think I don't have smoke for the press who made those publicly available. But it's the clerk's job to protect them. There is a push-pull between the press and courts, where the press asks for everything and the moon. It is up for the courts to protect what is properly protected and to allow access to the media and the public for what does not need to be protected. Sometimes that is a more tenuous balance than others. But when it comes to photos of the decedent, it's pretty clear across courts that those are not available to the media. They are regularly sealed, as they should be. They are seen by the jury. They do not need to make the rounds for eternity on social media, especially out of regard for the victim's remaining and living family members. So South Carolina is charging their former clerk of court, Becky Hill, and I will be covering it. She will be back in court. She is out right now on bail, and we will see where this case goes. I'd be surprised if it goes to trial, but her lawyers are going to have to evaluate the discovery and see what they have, and then decide if it's worth rolling the dice on this. I don't know if it will be. Speaking of judges that are mad at the media, it's time to go to Idaho. So talking about Idaho, the prosecution of Bryan Kohberger is slated to get underway with opening statements on August 11th, though that date might push back a little bit because of a Dateline episode, and Judge Hippler, is pissed. It's clear from the orders that have been put on the docket and from what was said in court, there was a closed court session to deal with leaks, and I am not saying alleged leaks, because I went back and watched the Dateline episode. I hadn't intended to till I saw what the judge said about it and his orders, but there is information in that Dateline episode that the media did not have. There has been a non-dissemination order from the beginning of this case. This case was moved more than 3 hours away from where the crime happened in Moscow, Idaho, to Boise to undergo trial because of the amount of publicity in this case. The non-dissemination order was to help reduce the amount of information known to the public so that the defendant could get a fair trial without improperly prejudicing the jury pool. And Dateline puts out an episode with images from the defendant's cell phone that would have only been had by the parties and their experts and law enforcement, with video that is not publicly available, with information that the prosecution experts believe that Bryan Kohberger was trying to, quote, forensically delete things off of his work computer. And in the episode, they said the prosecution's experts believe, or the government's experts. It was one of those two words. Among other things, Google searches that have not been made public yet, video from security cameras on a neighbor's house near King Road that had not been made publicly available, and so much more. And with that non-dissemination order in place, someone violated the court order, or numerous someones violated the court order in that Dateline episode that aired just last week, right before this court hearing. The judge is not happy and is asking the attorneys to get to the bottom of it. I wouldn't be surprised if we saw at a minimum charges for contempt of court for violation of the order at a minimum. So the amount of information put out in that episode could prejudice a jury pool if they watched it. It was a ton of information, and in my opinion, a lot of the information in that episode will not come in court. The amount of times the defendant was Googling Ted Bundy is not going to be evidence in this trial, and he was a PhD student in a criminology program, and one of the things that they were talking about him pulling up in a somewhat salacious manner was a paper about Ted Bundy written by one of his professors. He's a PhD student. Am I surprised? No. So to sensationalize things that are not going to be admissible in court and things that have an alternate explanation given his studies, and it's not going to come into court, an argument that maybe he became a criminology PhD so he could cover his tracks. None of that's coming into court. It is all too prejudicial, speculative, and it can't be proven. But the courts in Idaho have been frustrated with the media, along with courts elsewhere, and this kind of push-pull between courts and the media continues to bump up in these high-profile cases more than in some others because of the nature of the interest. But whoever leaked these, or whomever leaked these, it is going to be a big problem. And I've not seen a court take such swift, decisive, and potentially punitive at some point action as Judge Hippler has. But am I surprised that Judge Hippler's like, we're not fucking playing with this? Not at all. Remember, this is the judge that started when this case got transferred to him, essentially saying, I don't want to be here today. I would love to tell you all that I'm happy to be here, but let's not start off with an untruth, were his exact words. So let's take a look at what Judge Hippler had to say in his hearing about the sealed portion of the hearing, and then we're going to look at some strongly worded court orders. So let's go to the video of the hearing from the 15th on this issue.
In the closed session this morning, I indicated to you I am going to be entering an order requiring the retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour.
We have that
It
order.
does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor,
Right.
and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena
Right.
and the power to question witnesses under oath, as well as the power to grant immunity.
The
So,
judge wants a full inquiry
I
with the
will be
special
looking
prosecutor
for that from you.
and is asking the
And
prosecution
that one
to
just
do
deals
that.
with the state. I will get you one that deals with your side to preserve records, all right? All right.
Yep.
Anything else? All right, thank you. Why don't we come back in about an hour, all right?
So the judge is asking the prosecution to submit an order to appoint a special prosecutor to start the process to undergo an inquiry so that they can subpoena, they can question under oath, they can do a grand jury if need be, and they have the power, he said, of immunity, meaning if there's people that need to be given immunity who gave you this, then a special prosecutor can choose to do that. Now, do I think Dateline's going to fight on giving up their sources? Yes. Do I think this is going to take some deep digital digging? Yes. But that's why the judge immediately issued a do not delete your shit order. Emily, is that how you call it? Yes. The do not delete your shit order is now a second court order saying you have to preserve everything. And if there's evidence that things have not been preserved, then you can start getting into those areas of not just violating a court order, but potentially obstruction, depending on when they bring in a special prosecutor to undertake this proceeding. This judge is incredibly serious with how he's handling this. Before we get to those court orders, other things that the judge lined out in this hearing is that the two surviving roommates, when they testify, they will not be shown on video, audio only, that the court is going to continue to control the live stream through the court's own website, and that they will show essentially the like Zoom layout that we've been seeing, but they will add the witness stand. So it will be like a 4-panel screen showing the witness stand, the judge, and the parties. I like the way the judge has done it. You don't have one camera swinging back and forth. You don't have people doing extreme close-ups on the face of the defendant. And I think we will see more courts choosing to control their courtroom this way with the camera angles and just have fixed stationary cameras. Everyone can see what's happening. And I appreciate that approach versus having a single camera in the courtroom and having that controlled by media outlets versus the court controlling it. And it might be one of the ways to ease some of that tension between the courts and media is when the courts take control of their own streaming access and say, yes, we will control our own streaming access, and then we don't have to worry about it. It makes court accessible for everyone, especially in a case where so many are impacted and the court does not physically have room for everyone who might want to observe this case in court to actually physically be able to do it. It will keep the outside of the courthouse from becoming more of a circus and allows for access. I think it's a good balance. So this case will be streamed. I mean, unless some other fuckery pops off and the court changes his mind, but this case will be streamed. Certain witnesses will not be shown on camera, but will have audio. It's going to be about a 3-month trial. It's supposed to start at this point on August 11th. I just wonder if that date's going to be pushed back because jury selection is going to take longer with this episode out there. I don't know how many people are watching Dateline, but the media now coverage of the judge's response to Dateline, I wonder how much more that escalated people going to watch it. It's like, oh my God, the stuff's popping off. I should go watch the episode. I just wonder if the coverage of it then really just became the Streisand effect of the episode. Let's take a look at those orders. There are 2 orders issued by the judge that are these preservation orders, one issued to the prosecution team, one to the defense team. In a death penalty case like this, the lawyers have access to the discovery, but there are also a ton of experts that have access to the discovery. And when it comes to the prosecution side, there are numerous law enforcement agencies that may also have access to it. Hopefully it will be easy to track the digital trail of who had access to all the things that were in Bryan Kohberger's phone, including photos, searches, camera roll, and who had access to that security video, because not all experts will have access to all of those things. But there are a lot of people that could potentially have had access to this. I am not going to speculate on who could have leaked it. We're just going to look at what the court said, because I trust that they will find who leaked these, given the fact that the court is not going to let this go, and then we will know. But the difficult thing sometimes about court process is waiting for the answers to come in when something like this happens. But we're going to have to wait for the process to play out. I will say that the order to the prosecution is more strongly worded, in my opinion, than the order to the defense. You let me know what you think. We are looking at the May 15th order from the court that we just heard the judge referencing in the hearing. This is the document and records hold order for the prosecution. There's a separate order for the defense we'll look at next. Quote, based on sensitive information not previously publicly circulated that was reported during a recent Dateline TV program related to this case, footnote 1, and the defendant, Bryan Kohberger, it appears likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order. Such violations not only undermine the rule of law, potentially by persons charged with upholding it, but also significantly impede the ability to seat an impartial jury and will likely substantially increase the cost to be borne by the taxpayers of Latah County to prosecute this case by extending the time it will take to seat a jury and potentially requiring a lengthy period of juror sequestration. Accordingly, the court finds it is imperative to attempt to see that the source of such a leak is identified and held to account, and that doing so is the best deterrent for future violations. Accordingly, the court finds it appropriate to exercise its discretion by entering this order. It is hereby ordered that all persons who at any time, past or present, worked directly or indirectly by employment, contract, consultation, or otherwise for or on behalf of any law enforcement or prosecution agency engaged in the investigation or prosecution of persons for the murders that are the subject of this case are hereby prohibited from deleting, discarding, overwriting, destroying, altering, or otherwise making unavailable any, whether electronic or material, records, files, documents, metadata, messages, emails, text messages, direct or private messages, phone logs, or logs of communications, regardless of whether made or kept on a work-owned or personal account, device, or messaging app, that in any way relate to or document the fact or substance of communications with third persons, including representatives of the media or other persons or entities outside of law enforcement, which communications in any way relate to, refer to, or concern the investigation of Bryan Kohberger. The facts or allegations uncovered or reported to law enforcement concerning Bryan Kohberger or the investigation into the homicides that are subject of the current and then potential prosecution of Bryan Kohberger. All such documents, materials, or records that could potentially constitute a document, even if it is uncertain whether such met that criteria, shall be preserved and must be protected from deletion, alteration, or loss until further order of the court, like indefinitely. Any feature on any device or account that is set to automatically delete or overwrite information that could be covered by this order must immediately be disabled. Your Honor, you watching what's going on in Massachusetts, Your Honor? Are you watching the vanish mode? Are you watching the 30-day auto delete? Your Honor, that is damn thorough. Hey, if you have vanish mode on, turn it off. You're set to auto delete, turn it off. Preserve everything. And do not fuck with me. I added that last part. It is further ordered that within 7 days, mind you, this said 14 and it was lined out to 7. Within 7 days, the state shall submit to the court in camera a list of all individuals within law enforcement and prosecuting agencies, past or present, who are known to have had access to any facts related to the investigation of defendant, including but not limited to surveillance videos of suspect vehicle 1, that was in the Dateline episode, the AT&T records for defendant's cell phone, also, the content of defendant's cell phone, yes, and other electronic devices and social media accounts, those are related, including internet search history, photographs and information associated with defendant's Amazon account, or any such information referenced in the above-mentioned Dateline episode regarding this case. The state is further required to provide a copy of this order to all such individuals and document that it has done so. Give everyone notice and show me that you gave them notice. Every law clerk, the FBI agents, law enforcement from multiple law enforcement agencies, prosecutors from multiple prosecuting agencies, because the state's attorney general has prosecutors working on this case, anyone they worked with, and document that it's done so and bring it back for me to check your work. Show me that you've told everyone to preserve this. Talk about an uncomfortable Zoom hearing when you have to get everyone together and be like, so, by the way, the court said this. Failure to comply with this order may be a basis for a finding of contempt of court and such other civil and criminal consequences as may be appropriate. Within 7 days, the state must also provide to the court a written plan designed to address and prevent the future unauthorized disclosure of information related to this case and what it has done or proposes to do to identify any violations of this court's non-dissemination orders previously entered in this case and those responsible for such violations. Show me your work and tell me what you are going to do to fix it. And identify everyone who could have had access to this information. The court literally said name them and reminded everyone that there can be contempt of court orders that this court can find in addition to civil or criminal consequences. Let's read the order to the defense. This is also from May 15th. This is the document and records hold order for the defense. And it says, based on the sensitive information not previously publicly circulated that was reported during a recent Dateline TV program related to this case and the defendant Bryan Kohberger, it appears likely that someone violated this court's non-dissemination order. Such violations not only undermine the rule of law, potentially by persons charged with upholding it. And then the language is the same. Importantly, such violations potentially frustrate the ability to ensure both sides receive a fair trial. Accordingly, the court finds it's imperative to attempt to see that the source of such leak is identified. Accordingly, the court orders as follows. And then the court goes through the same hold information. Anyone who is worked with the defense, employed, contract, consultation, or otherwise, all of the same hold requirements. It then says that lead defense counsel shall submit to the court in camera a list of individuals within their team, past or present, who are known to have had access to any facts related to the investigation of the defendant, including but not limited to, and then it lists out the same items that were listed out. But the prosecution has been charged with undertaking the investigation, and the languaging in the defense order is a preservation, but the language is much broader. Someone leaked this. But in the prosecution's order, it says likely connected to the prosecution team or law enforcement. So we see where the court's head is at a little bit, I think, and we will see what happens from here. We are not near close to done with this inquiry. And do you think that this judge is going to let it go? I sure don't. The judges are pissed. The trials are trialing. And this case is slated to start opening statements August 11th, and that might get pushed back because of the additional media attention close in time to trial. You can't move the case again easily. You can't move it to another state. You can't move it to another county. And now the judge is considering a potential 3-month sequestration of jurors, which is going to make it even harder to find a jury. It's already hard to find a jury in a death penalty case. And then you add the high profile nature of it, and then you add the potential for sequestration, it is going to possibly overshoot the time for opening statements to begin. I'll keep you posted, but for now, we need to get to court in the Karen Reed case. So make sure that you have the Law Nerd app and are joining me on our daily adventures in court, because who knows what's going to happen in court day by day in that trial. And you don't want to miss the moments that you're going to be hearing about here later. You want to be in the chat when it all goes down. So make sure you have the Law Nerd app so I can keep you in the loop. Thank you for being here. Thank you for being a Law Nerd. I will see you in the next one and on the Emily Show podcast with the daily case briefs to keep you in the loop with that case if you don't have time for day in and day out of court, which I completely understand. So I'll see you soon. Bye. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.